Welcome to today's panel discussion on the role of OSHE legal requirements in business management. With us today, we have three experts who will be discussing this important topic. First, can one of you give a brief overview of what OSHE stands for and what it covers?
Okay, OSHE stand for Occupational Safety, Health and Environment. It refers to the law and regulation that are in place to ensure that companies are protecting the health and safety of their employees and the environment. This can include everything from workplace safety and hazard identification to environmental protection and workers' compensation. OSHA in Malaysia cover a wide range of topics related to occupational safety and health, including hazard identification and control, emergency preparedness, and the provision of personal protective equipment.
Thank you. And what is the role of OSHE legal requirements in business management?
The role of OSHA legal requirements in business management is to ensure that the company is operating in a safe and responsible manner. It is the responsibility of management to ensure that the company is complying with these requirements, as failure to do so can result in legal consequences. It's important to note that these requirements are not just there to protect the company from legal consequences. They are also in place to protect the health and well-being of employees and the environment. By ensuring that the company is complying with OSHA legal requirements, management is taking an active role in promoting a safe and healthy work environment.
Right, so that's a good point. So how do business go about complying with OSHE legal requirements?
Okay, there are a few key things that business can do to comply with all legal requirements. First and foremost, it's important to identify and assess potential hazard in the workplace. This can include everything from physical hazard, like machinery, and chemical to physiological hazard, like stress and burnout. Once these hazards have been identified, the company can implement control to mitigate them and monitor the effectiveness of these controls.
Right, that makes sense. And what about training and personal protective equipment?
Right, that one also included, as well as the provision of a safe and healthy work environment. Training and personal protective equipment are also important for ensuring compliance with OSHA legal requirement. Employees need to be trained on how to work safely and protect the environment, and they need to have access to the necessary personal protective equipment to do so. This can include things like hard hats, earplug, and respirators. Depending on the specific hazard present in the workplace, the Act requires employers to take all reasonable steps to ensure the safety and health of their employees at work.
Okay, speaking of which, is there any right or free of charge on providing employees with personal protective equipment?
In some situations, it is not possible to completely eliminate a hazard or reduce exposures to a safe level. So, respirators, goggles, earplugs, gloves, or other types of personal protective equipment are often used by themselves or in addition to other hazard control measures. Employers must provide most protective equipment free of charge. Employers are responsible for knowing when protective equipment is needed.
Okay, next, what is the sectors OSH don't cover under the Act?
There are three of OSHA approved state plans regionally. The first is the approved states for private sector and public employees. The second one is federal OSHA for private sector and most employees. And the third one is OSHA approved state plans for public employees only. Private sector employees are covered by federal OSHA. So the sectors does not covered are self-employed, immediate family members or farm employers, and workplace hazard regulated by another federal agency. For example, the Mine Safety and Health Administration, the Department of Energy, or the Coast Guard.
Right. So, could you make it clear to us what are the responsibilities of an employer?
Of course, employers have the responsibility to provide a safe workplace. Employers must provide their employees with a workplace that does not have serious hazard and must follow all OSHA safety and health standards. Employers must find and correct safety and health problems. OSHA further require that employers must try to eliminate or reduce hazard first by making feasible change in working condition, switching to safer chemicals and closing processes to trap uh, harmful fumes or using ventilation system to clean the air are example of effective ways to get rid of or minimize risk rather than just relying on personal protective equipment such as mask, glove, and earplug.
Employer must also prominently display the official OSHA poster that describe right uh, and responsibility under the OSHA Act. This poster is free and can be downloaded from www.osha.gov. Inform workers about hazard through training, label, alarm, color-coded system, chemical information sheet, and the other method. Train worker in a language and vocabulary they can understand. First one, keep accurate record of work-related injuries and illness. Perform tests in the workplace such as air sampling required by some OSHA standard. Provide hearing exam or other medical tests required by OSHA standard. Post OSHA citation and injury and illness data where worker can see them. Notify OSHA within 8 hours of a workplace fatality or within 24 hours of any work-related inpatient, hospitalization, amputation, and loss of an eye. Not retaliate against worker for using their right under the law, including their right to report a work-related injury or illness.
Right. Thank you all for sharing your insights on the role of OSHA legal requirements in business management. This has been a very informative discussion. So, okay, now we move to a slightly different discussion. So, it's a discussion about on OSHA in Malaysia and its salient features. So, with us today, we have you guys as an expert who will be sharing their insights on these important topics. So, first, can one of you give a brief overview of what OSHA is and what it covers in Malaysia?
So OSHA stands for the Occupational Safety and Health Act. It is the main legislation in Malaysia that cover the health and safety of worker in the workplace. It set out the right and responsibility of employers, employee, and other stakeholder in relation to occupational safety and health.
Thank you. And what are some of the salient features of OSHA in Malaysia?
One of the key features of OSHA in Malaysia is that it applies to all employers and employees, regardless of the size or type of business. This means that all companies are required to comply with the provisions of the Act, regardless of whether they are a small business or a large corporation. Another salient feature of OSHA in Malaysia is that it provides for the establishment of an Occupational Safety and Health Council, which is responsible for advising the government on matters related to occupational safety and health. The council also plays a role in promoting awareness and understanding of OSHA among employers and employees.
Okay, other than that, OSHA in Malaysia also contains provisions related to the reporting and investigation of workplace accident and incidents. These include the requirement for employers to report certain type of accident and incident to the Department of Occupational Safety and Health, and for the department to conduct investigation as necessary.
That's quite interesting. And what are some of the penalties of non-compliance with OSHE in Malaysia?
Under OSHA in Malaysia, employers who fail to comply with the Act can be subject to range of penalty, including fines, imprisonment, and even closure of the business. The severity of the penalty will depend on the nature and extent of the non-compliance, as well as any harm and injury that may have been caused as a result. In addition to penalty for non-compliant mentioned above, OSHA in Malaysia also provide for the precaution of non-compliant method. Uh, OSHA in Malaysia also provide for the precaution of employers or individual who recklessly or intentionally expose employee to risk of injury or death.
Yeah, I heard the Act also contains provision for the settlement of disputes between employers and employees related to occupational safety and health. So this includes the establishment of a system for conciliation and mediation, as well as the establishment of an initial court to hear and determine cases. So is there any other provision from OSHA?
Yes, there is. OSHA in Malaysia also contains provisions related to the inspection of workplaces by the Department of Occupational Safety and Health. Inspectors have the authority to enter workplace and carry out inspections to ensure compliance with the Act.
Right, so there are few of rights information in hazards. Those need to be embedded in each employee. One of these is the right to know about the chemical hazard. So could any of you clarify it?
Okay, the the hazard communication standard known as the right to know standard require employers to inform and train workers about hazardous chemical and substance in the workplace. Employers must provide workers with effective information and training on hazardous chemical in their work area. This training must be in a language and vocabulary that worker can understand. Keep a current list of hazardous chemicals that are in the workplace. Make sure that hazardous chemical containers are properly labeled with the identity of the hazardous chemical and appropriate hazardous warning, and have and make available to workers and their representative safety data sheets, formerly known as material safety data sheets, for each substance that provide detailed information about chemical hazard, their effect, how to prevent exposure, and emergency treatment if an exposure occurs.
Right, that's quite details of such information. So the other right that I know of is for roles and rights. So what about it?
For that aspect, employers must display the official OSHA poster, job safety and health. It's the law. In the place where worker will see it, it is can be downloaded from OSHA website, www.osha.gov, or pre-print copy can also be obtained from OSHA.
Okay, understood. Another thing, what about the records in the workplace then? Because there must be a consideration to be put into documentation, right?
Yes, you are right. There is one for it. It is an OSHA right to get copies of workplace injury and illness records. OSHA's record-keeping rule requires employers in higher hazard industries with more than 10 employees to keep accurate and complete records of work-related injuries and illnesses. Certain low-hazard workplaces such as office are not required to keep such records. Employers must record any serious work-related injury or illness on the OSHA Form 300. A serious injury or illness is one that required medical treatment other than first aid, restricted work or days away from work. Details of each incident are entered on a separate form, the OSHA Form 301. This OSHA Form 300 becomes an ongoing log of all recordable incidents. Each year, from February 1 to April 30, employees must post a summary of the injury and illness log from the previous year in a place where workers can see it. Workers and their representatives have the right to receive copies of the full OSHA Form 300 log. Following a request, employers must make copies available at the end of the next business day. These injury and illness logs are important because they provide a comprehensive guide to possible hazards in the workplace that may need to be correct. The logs should be used to focus on areas with high injury and illness rates and to find and fix hazards in order to prevent future occurrences.
Alright, thank you. That really did clarify the details on that one. Oh yeah, another thing, is there one for medical?
Yes, there is some OSHA standard require medical tests to find out if a worker has been affected because of exposure at work. For example, employers must test for hearing loss in worker exposed to excessive noise or for decreased lung function in workers exposed to asbestos. Workers have a right to their medical record. Workers' representatives also have a right to review this record, but they must first get written permission from the workers to gain access to their medical information.
Another addition, right, that works must know in the right to exposure data. Many OSHA standards require employers to run tests of the workplace environment to find out if their workers are being exposed to harmful level of hazardous substance such as lead or asbestos or high level of noise or radiation. This type of tests are called exposure monitoring. OSHA give workers the right to get the result of the test.
Alright, so thank you for sharing your insights on OSHA in Malaysia and its salient features. This has been a very informative discussion. So yeah, so we know that from this discussion or forum that for this Occupational Safety and Health Act for 1994, this is mainly to ensure safe and helpful working conditions for working men and women by authorizing enforcement of the standards developed under the Act. So by assisting and encouraging the states in their efforts to ensure the safe and healthy full of working conditions. So this is by providing for research, information, education, and training in the field of occupational safety and health. So I think that's all for our forum today. So I think thank you for all the panelists that attended for this forum. So and giving us such a big opportunity to have this great deal of discussions about this safety and health standards. So I think that's all for today, and thank you guys for this sharing session.
Okay, thank you for all.
Thank you.